protection is basically a paradigm shift from previously what we used to do is that, whenever a purchaser is purchasing something, whenever a service is being taken, what used to be is that the person who is receiving it, he has to look carefully about all the things. And you go to bazaar, pick aloo, you select yourself what you are taking. Now, with the introduction of the Consumer Protection Act, previously it was 1986, then subsequently it was reenacted by repealing the earlier act. We have now 2019. Here, and in the previous act also, the paradigm shift is caveat vendator. What is caveat vendator? Being a law student, you might be acquainted of this term, that the seller be aware. Seller, not buyer. Previously it used to be seller. Now, previously it was buyer, now it is seller. The seller has to be aware what he is selling to the consumer, to the customer. This paradigm shift has caused a lot of trouble to these sellers, to the manufacturers, to the service providers. Now, as I was telling regarding the person who can file a consumer case, there are a few points that I also want to add here. Is like, who can file a case, who can file a suit? Sir told that who can and who cannot. Okay, for example, in case of resale, you cannot file a consumer suit. Resale, what is resale? I have purchased a second-hand bike, I have purchased a second-hand vehicle, and I am selling it to you. You have taken it. Now suppose I being a seller, I have sold you. You have taken it. But if I being a seller is taking it for reselling it, I cannot be a consumer. Why? Because I am doing a business here. Right. So there is a distinction. Now this distinction has been further substantiated in a landmark judgment, that is Lakshmi Engineering Work. Here the court has differentiated what is meant by commercial purpose. Now if I resell it, the illustration that I have given you, that illustration says that I am doing it for a commercial purpose and I cannot do that, right? In the same line, the court has differentiated here what is meant by commercial purpose and what is not meant by commercial purpose. For example, if I have taken a car and I have given it to a driver and he gives me every day 30 rupees, 40 rupees, 100 rupees, 2000 rupees, whatever, per day. Okay. Now, if I find some default, some fault in the vehicle, can I, who has given it to somebody else to, to use it, can I file a case? Yes. The answer is no. Why? Because I am doing a business there. Now, if the same person, I have purchased it and I drive it myself and ply it in the roads of Calcutta, take people from one place, deliver them on the other place, and I'm doing this on a regular basis, and I find some fault in the vehicle, I can file a case. Why? Because this is called the livelihood. When you do it for a commercial purpose, you give it to somebody else. The main intention here lies is differentiating the commercial purpose, is differentiating livelihood and differentiating it from being used for commerce, for gaining profit. I may have 10 vehicles, I may give it to 10%, they are gaining profit, they are giving it to me. I am doing a commercial purpose. But if I drive it myself, use it myself, I am doing livelihood. So I can sue there. So this case, the Lakshmi Engineering Work, which was in the year 1995, the court has appropriately distinguished between the commercial use and livelihood, where it can be distinguished. So the prima facie thing that has to be looked into is what compels you to file a case. Now, if there is a defect, the second thing you have to look into is that you are using it by your own for livelihood, or you are using it for gaining profit from it. Then there is one more thing, very important. is contract of service and contract for service. Being a law student, you might be knowing it. Can anybody volunteer? What is the difference between contract of service and contract for service? Anyone? Okay, let me elaborate on that. Contract of service is, now first let me tell you that a person having contract for service can sue in the court, but contract of service cannot. Remember this, contract for service can sue in court, contract of service cannot. Why? Where is the difference between these two? A very thin line of distinction is there, and the distinction is contract of service. For example, I have hired in my firm a CA, chartered accountant, to file the income tax things and do all the compliances and all. He had been doing for the firm. Now if I tell him that you please file my also income tax, my personal income tax, okay, not that of the firm, not that of the company, but of the firm, he is not being paid for that. He is doing it and he has done some wrong in that, and for that, subsequently the income tax penalizes you, imposes penalty on you. So what the chartered accountant has done, he has done the service, it is contract of service. He is in service with you, under your direction, but not independently. Contract of service is what? It is distinct from it. In what sense? There the person has the rationality, the power to take the decision. For example, I have a driver, I tell him you drive here, you drive there, or you overtake that car, contract of service. If he does any wrong, it is the wrong of the owner, because it is contract of service. In the same way, if I hire a car service, I tell him you take me to the airport. The driver is taking me to the airport, but he is delaying it, he is doing something mischievous, he is doing something wrong. It is contract for service. I can sue him. For example, I have taken an Uber bike, Uber Moto. I am asking somebody, Uber Moto, you drop me to this end. This Uber Motor service has come and taken me, and he is riding like this, like doing wheelie kind of things and all. So, and that caused an accident. I got hurt. At the same time, I could not reach my place. Suppose I am having some kind of interviews, or having some kind of engagement. I could not reach there. I am hurt also. Now here I have availed the service. It is contract for service, and I can sue for deficiency of service. Why? Because of his negligence to ride, to take proper safety precaution while driving. He has not done that. So in default of that, I can charge him. But if I sit with a friend of mine, an employee of my company, you take me, and he takes me. It is contract of service. I cannot sue him because there is no relation between them. There is no ethics between them. So that divides. Now this also leads me to one more thing where we can file cases. The broad aspect or the spectrum is to understand it always works on business to consumer. Business to consumer. Somebody is selling me and he is a businessman. Now suppose I am taking a flat from promoter as being instructed as by Sir Arun sir. He said, given an illustration that I am purchasing a flat, service is included in it from a developer. Developer is a businessman. Okay. If I purchase a flat, suppose from somebody known to me or unknown to me, he is not a person who is doing business. He is just selling one flat and will purchase another flat. He is not a businessman. Here, if he does something wrong, for example, he has taken the money, not registering it. Can we do that? Can we call him to the court, consumer court? Anyone?
Yes.
The dealing is between two private persons. No business here. You have to understand the business, the commerce element in it. The commerce element is missing in it. The commerce element, if there, it is okay. If there is no commerce element, there is no consumer relation. So in absence of the consumer relation, we cannot do that. Now, after coming out from here, what are the other factors that affect a person from filing a case? See, basically, I am discussing all these things. There can be other ambits to discuss, but you are the law students, future advocates, future lawyers. A person who may be, today you are the consumer, we all are the consumers. You may have to understand, you better understand the consumer law and the law because you have the law background there, right? So therefore I'm discussing that pure technical and legal thing with you. So what is the jurisdiction of a consumer court? Basically, we all know there are two types of jurisdiction. Can anyone volunteer? Two types of jurisdiction to file a case? Yes? That is called the pecuniary jurisdiction. The other one is a territorial. Territorial pecuniary. Right? Now, territorial means what?
Area.
Where a person within whose court the case has to be filed. Clear? Now, I reside within the jurisdiction of particular thana, Iqbalpur Thana, Park Street Thana, something. Now, we have to see where this court falls. Which court has the power to deal with the cases under this thana? Now, if it is Park Street, then we have the DCRC in Calcutta, one, we have to file there. It is clear. For example, if you go to another district, Bolpur, district we call Murshidabad, there is only one district. Irrespective, there is only one DCRC, one district Consumer Redressal Commission. So wherever you are, within which jurisdiction you are, you can file it in one district, DCDRC we call it, you can file it there. Now who can file it? So that is the territorial jurisdiction. In territorial jurisdiction, who can file in this? First of all, I say it is the last one in the list, but I say it first. Why? Wherever you reside, you can file there. That will be your jurisdiction. Territorial, the first. Wherever you work for gain, you being a consumer, you work for gain, you can file it there. So, as a consumer, you have two criteria. Wherever you live, wherever you work for gain, you can file a case there, within that jurisdiction. Number two, I take it second. Otherwise, it is the first part, where the businessman, the seller, resides, works for gain, he has a branch office or where he carries on the business. If there are more than one, you can choose anyone wherever they live in, be it in different areas, in localities, you can choose anyone. Depends on you. Nobody will object you. You can choose that jurisdiction. The third one, where the cause of action arise or has arisen, be it wholly or in part. In these three things you can file. In these three. That is the territorial jurisdiction. Now what is the pecuniary jurisdiction? The monetary jurisdiction. Now for example, any consideration paid. Now this is again very important part, very important. I am purchasing a flat, underdeveloped flat, under construction flat, worth 3 crore rupees, 3 crore. The jurisdiction lies with the National Commission. But I have paid only 10 lakhs. So the jurisdiction will be determined on the amount I have paid. The law is clear and settled here. Be the whole amount, be 3 crore, irrespective, not an issue. Whatever you have paid will determine the jurisdiction. So it will not go to the National Commission, it will come to the District Commission where you live. Okay? So the consideration paid is very important here to be to understand. Now, above 50 lakh and within 2 crore, it will be the State Consumer District Redressal Commission, SCDRC. So, again, taking the earlier instance, 3 crore property, I have paid 50 lakh, 51 lakh. I'll not go to District Commission. Where I'll come? I'll come to the State Commission. Why? Because I have paid amount which is higher than the pecuniary jurisdiction of the district commission. This is clear? Now above 2 crore, the national commission. This is clear? Now what are there other things that is being done by these commissions? State commission, they can, besides entertaining the complaint, state commission I am talking of, they will entertain the appeals, the revisions. Okay? Now what is appeal? Can anybody from this side appeal? What is meant by appeal? Challenging an order. Okay? So when we talk about appeal in consumer sense, we mean the finality of the order, determination by the lower court, right? So when the lower court has already determined what is the right of the persons, the opposite party and the complainant, challenging this ultimate order, the final order, which we otherwise call judgment, we have to file appeal. Okay? So appeal, when we speak of appeal in consumer, we say that against the final order or judgment of the district commission, appeal is being filed. So from the order of the lower court, that is the district commission, it has to come from the state commission. And against the order of the state commission, it will go on to the national commission. For example, 51 lakhs paid consideration, the matter directly goes to the state commission. So the state commission has tried the case, the consumer case, and he has filed and he has given the judgment, the verdict. Now challenging this verdict, a person has to go to the national commission, right? Then there is another provision that is called the revision. Before coming to revision, let me tell you. Now, what is the time limit for filing the appeal? From district commission to the state commission is 45 days. From state commission to national commission, it's 30 days. Can you tell me the difference? Why 30 days from 45 days? Why it has reduced? Why? Anyone? See, this question is going to help you out in understanding the laws. You will get this kind of law, this kind of thing in a lot of places, not in the consumer protection only. In various laws you will get that. When you go to the higher forum challenging something, the time reduces. Why? From the trial court to the upper court you go, it reduces. Why? Pardon? Anything else? Okay, that is okay. Anything else? Actually, the concept behind this is that the person has already litigated a long time in the lower court, right? Then he has filed an appeal, sufficient time is being given. The first appeal is very important. Why? And in the legal sense, why? Because you have to bring up all the issues under one basket and place it before the higher court, from higher than the trial court. So it gives you additional 15 days time. But when you go for second appeal, court understand that you have taken everything in the lower court now, you don't require that much time, and you have already litigated in the lower courts and you have given a sufficient time there. So time has to be curtailed. So when you come from the lower court to the higher court, the time lessens actually. Okay. So there is a rationale behind 45 days the first, then 30 days and all those things, it goes on. So then we have the revision. Revision. What is meant by revision? Can anybody volunteer? When do we file a revision? Yes, please. Okay. This is, I basically understand that you have meant in the sense of CPC. This is what is being done. But there is a slight difference when we talk about the Consumer Protection Act. When we talk about appeal means totally the matter has ended in the trial court. Then appeal lies. Now, in revision, day to day, a lot of interim orders being challenged, a lot of things being done by the court. In the revision, the matter stays with the trial court, in the lower court. And the lower court has given some order. Now, you want to challenge that order, and you have to come to the revision. Okay? So here the difference is the main suit has not been determined, has not been adjudicated by the trial court, by the lowest court. It has not been adjudicated finally. Matter remains. Keeping that matter pending, you have some challenge, some order passed by the court. That becomes revision. Now, in revision, what are the grounds basically that you take? What are the grounds? Anyone? Okay. Basically, he is giving 90% of the answers. Nobody else is, trying to at least coming up next to him. Anyways, it's good, appreciable. Thank you. A clap for him. So, revision is basically done when we allege that the lower court, lower commission has used the power, not vested in it, exercised the power, not vested in it, or has not exercised the power, so vested in it. ওনার পাওয়ার আছে, উনি কাজ করেননি, অর্ডার দেননি, কিংবা ওনার পাওয়ার নেই, উনি অর্ডার দিয়ে দিলেন, or has acted illegally or with material irregularity. These are the basic three criteria we have to bring in our revision petition to bring it under the ambit of revision. Then only it is acceptable in the higher court, otherwise it is not. Okay? Now, there is one more provision which is about review. What is review? Anyone? Yes? Most welcome. Say. Very good. So what he has said is that absolutely correct, absolutely correct. But CPC has restricted review a bit. The provision of review says that error apparent on the face of record. No other ground given other than that. If there is an error in the name, spelling, date, amount, place, goods, anything, any detail, any mistake in the judgment being given, in the order being given, that can be brought by the, that can be brought before the attention of the court, saying that this is the mistake, this is the error apparent on the face of record, can be rectified. Court can do that suo motu on its own or on the application of the aggrieved party. Apart from that, whatever you have said, it is applicable in CPC. For example, there is a change in circumstance, something which was not there at the time of passing of the judgment, all those things are there in CPC. Those are the other grounds that you can bring while not under the Consumer Protection Act. In other cases and all. So in short, if I have to say, this is the litigation process that I have tried to, convey to you all. So in short, this is the process, how we can file a case, what has to be filed, where it has to be filed, what is the jurisdiction, what is not, and all those things in short. Otherwise, it will take a long time. I believe I have already completed everything what I have to say in the short span of time, and thanking you all. Thank you.
So, sir have very well explained the term caveat emptor to caveat vindicator. Previously, it was buyers beware, and now it is sellers beware. Sir has also talked regarding the appeal, review, revision, jurisdictional bar under Consumer Protection Act. Thank you, sir, for briefing us your expertise in the field of consumer protection law.